Hello there. In this video I'm going to take a look at employer's liability in negligence claims. Negligence is a civil wrong, it's a tort, and the likes of a personal injury, for example, that you might have suffered in the workplace, whether it's a physical injury or whether it's a psychological injury, is essentially a negligence claim. So you would be claiming to prove your injuries, and obviously you need to show causation between the employer and your injuries, the injuries you've suffered, in order to prove that your employer was negligent. So if you can do that, well then you will succeed with a personal injury claim. If you can't do that, you won't. This video is going to look at employer's liability and essentially what you need to know. It is probably more suitable for employers, but obviously for employees it's going to give you a good steer on whether, if you've suffered an injury or claim you've suffered an injury as a result of your employer's conduct, then it'll give you an idea as to whether you might have a claim or not. So essentially there's a whole well-established, well-known principle that an employer owes a duty of care to his employees. What is the extent of that duty of care? This is an important question. An employer is not an insurer. So, an employer is not required to guarantee that nothing can go wrong, but he does have a fairly onerous duty of care. The duty of care essentially, or the standard of care, will have been discharged if he does what a reasonable and prudent employer would have done in the circumstances. Okay, so it's an objective test. It's what the reasonable bystander, the reasonable person would say that is a prudent and reasonable employer, or they were reasonable actions that the employer took to try to ensure that risk did not occur. So for an employee then to win a claim in negligence, to win a personal injury claim, he must show the employer was in breach of his well-established duty of care. The courts have not, however, laid down one single duty of care, and it is that of the reasonable, prudent employer. But the courts have recognised that the duty of care will vary in circumstances depending on the employee's age, experience, knowledge, and the risks inherent in the particular type of work. So obviously if the situation arises with an employee who is a very, very well experienced employee and there is not much risk attached to the particular job and he's been doing it for 20 years, a different standard will be placed on the employer in those circumstances versus a young employee who has just perhaps graduated or qualified as an apprentice and is carrying out risky work. Clearly there's a higher duty of care on the employer in those circumstances, and it does come back to what would a reasonable and prudent employer do. You need to be aware also that the employer's liability in negligence is a different thing from a breach of statutory duty by the employer. So an employer has duties under the Health and Safety Acts, for example, and various regulations. So if he's in breach of any of those regulations or any of those provisions of the Acts, well, clearly he's in breach of a statutory obligation. That is a different matter from employer's liability in negligence. But obviously if you're going to be bringing legal proceedings, well then you can sue under both headings, breach of statutory duty and in negligence. An employer can be held liable for physical injury, psychiatric injury, that is non-physical, psychological or psychiatric injury arising from the conditions in the workplace, and that can arise, for example, in a bullying claim, in a stress claim, in a harassment claim. You may claim to have suffered psychological or psychiatric injury due to the employer's failure to provide you with a safe place of work and to provide you with a place of work that was free from bullying, harassment or overbearing stress. The employer will also be liable for property damage. The assessment of the employer's liability then will really come down to four broad principles or four broad areas. One is an obligation on the employer to provide competent staff. Two is to provide a safe place of work. 3 is an obligation to provide proper tools and equipment. And 4 is to provide a safe system of work. These are the sort of things that a court will be looking at in order to assess an employer's liability in a claim for negligence or a personal injury claim. The employer's negligence must have caused the injury, so in order for you as an employee to succeed with a claim, it is not enough just to show that you've suffered an injury. You must show causation, you must show a connection between the employer's conduct, the employer's negligence, and the injury that you've suffered. There's also a question of foreseeability. Was the injury foreseeable? In other words, if it was so outrageously unpredictable and unforeseen, it may be the case that the employer won't be held liable. But generally, certainly, even though you may be able to prove you've suffered an injury, you will have to prove that there is causation or connection between the employer's conduct and your injury. That's in order to prove negligence. The employer's duty will be discharged if he does what a reasonable and prudent employer would have done in the circumstances. So that is the reasonable employer sort of test that a court will apply to establish negligence. And the reasonable employer test is an objective test, as I said already. It's what a third party or an innocent bystander or an objective bystander would say, yes, he has behaved reasonably, and that is reasonable. It's not a subjective test. And he'll discharge his duty of care if he's not done this, then he may be liable for an injury arising from that failure, provided the negligence, his failure to discharge his duty of care, caused the injury. My name is Terry Gorry. I'm a solicitor in Enfield. My contact details are there on the screen. If you find this video useful, you might give it a thumbs up down below, and I have a useful, or what I think anyway, is a useful YouTube channel on which I cover many aspects of Irish law, employment law, business law, family law, drink driving, property, buying houses, small business, and so on. So you might be interested in signing up for that or subscribing to my YouTube channel. Thanks for watching.